So,
Good morning.
good morning, good morning. So,
Good morning, ma'am.
good morning. Uh, so, welcome, Archana, to this fourth session that we are doing in the flying kites. We're calling it Flying Research Kites and a joint exploration of research. So, we're really glad that you are joining us here because I want sort of not so much in terms of designation, but in terms of work. Archana has been, I think, for a very long time, both in legal education and research, has been asking for people to get off the beaten track or to look at the beaten track from very different lights, not to sort of like to say that if you just change the angle from when you are seeing what you're seeing, you start seeing different things. And she did this amazing, it was her doctoral work, but it was also something which had a huge influence on family law reform discourse in India, where she had spoken in terms of how like a lot of what we see as family law legislation has been very heavily manipulated by what the British required and their understanding of personal laws they superimposed on how we had to be looking at the whole question. And I mean, in the sense of, because she did an entire historical exposition of it, she was able to show that when you are just, like swallowing what other people keep doling out to you, and you don't go back and look at, is this really the story? Then that's wherein you sort of get trapped into, thinking that there is nothing more required to be done. And Archana has carried on with that in all other works, even in the way she does her own, like her teaching, is to be sort of seeing that there is such a lot of unfamiliar in the familiar. And I think it's in that context that we have requested her, because family law, irrespective of what, will remain a kind of a, what should I say, one of the critical areas that we'll all have to engage with. It is, of course, a mandatory subject, but more than that, I think that there is that huge influence of the personal on the political and of the political on the personal. And I think that intersection, the manner in which Archana sees it, and consequently provides you with a whole new area of being able to do research. The thrust of this series has been to try to say that whoever said that because you're doing research in law and because we are so very dominated by precedents and other things, that we can't find fresh pastures. I think it's in that context that we have requested Dr. Parashar, who has been associated with Macquarie University for long, who's also adjunct professor with us here at Nalsar, and is kind of one of the, I would say, the country's renowned scholars in family law and in the whole area of gender, legal reform, and legal education, to speak with us. So welcome, Archana. The procedure that we follow basically is that you get to speak for about, 45 to an hour. You can, I mean, I think, Irfan Saab, you make the presentation button available, because she has a presentation. And she's also promised the participants that she'll be happy to share the presentations with you later. So you speak for about an hour, after which we give everybody, including you, a 10 minutes break to reflect on what you have said. And then participants, type in their questions into the chat box, and Vasanthi will moderate that discussion so that, you don't have to both read and answer. So she also, what we find is that everybody gets addressed if you cluster their questions into thematics and stuff. That's the way we carry on. And then last 10-15 minutes, if like time remaining and everything, we allow people to unmute themselves and directly ask questions. That's the model that we have been following. Yeah. So welcome, and it's over to you. I think is your microphone.
You are still muted.
Now it's
Now.
all right. Thank you for the introduction. And yes, I'll try to do what all you have asked me to do. But people can always ask me to address issues that they think that I haven't answered. As Amita said, I would like to share my presentation with you. So let me just first try to see if I can do that now. Can somebody help me with this?
You have this icon which says present now or something. I think that's what you have to press.
Yeah, I've done that. Then what do I do?
Then you should have opened up your presentation.
My presentation's already open. Can people see it now?
No, we can't see it.
So something else has to be done.
Irfan sir?
Sorry.
No, that's I'm asking the IT support person to sort of see what is happening.
Is he in the meeting? That I don't see him here. Maybe I'll just call him.
Okay.
While we are doing this, can I ask the participants, are they all of them from or from other institutions? Just to get an idea of who I am talking to.
People are from all over, not only from Nalsar.
Right.
Yes, Shiba, you can.
Ma'am, it was by mistake. Sorry.
Archana, when you press that button of present now, I have it active on mine, so it should be active on yours also.
So
next to the hand, there is an arrow which goes upwards. If you press it, it should then allow you to share your presentation.
Can people see it now?
Yes, we can. Now you just make it full slideshow and it'll be perfect. Go ahead. Just make it like a slideshow. Like from the beginning. Yeah, right.
Yeah, it is. So okay.
No, if you do it from the beginning, because at the moment we can still see your side slides.
Yeah, I can't get rid of them. Start slide.
You can. You go to you click on the slideshow.
It's not allowed to do anything.
You say from the beginning.
Yeah. You're still not allowing.
No, that's not a.
Yeah, I used to be always able to do it, but there's some issue here. So, okay, just keep, ignore
the... Say from current slide. Let's just just try that one. Younger people can always help,
Yeah, let them do.
Because usually they'll have some totka कि ये कर लो तो फिर वो ठीक हो जाता है.
Okay, let's just keep the side panel on.
Okay, fine.
Okay, so just hello everyone, and I'll try to start the topic. As Amita said, I have spent large part of my life researching and writing and on family law. It is a subject that is very important to me, and I would like to share my enthusiasm for it with you, and hope that you will choose to think about it as a possible area for you to do your research in. So the outline of my presentation today is that I'll talk very briefly about setting the parameters of research in any area, including family law. What does a requirement of original research for a PhD entail? And the kind of research that you choose to do, you have to make a choice, whether it is theoretical or empirical, but I'll go on to explain to you that I don't think that this is an either or choice. Then I go on to conception of knowledge. And this is where I want to focus most of my talk today, that in doing research, the fundamental questions that you ask are invoking your understanding of legal knowledge. And this is where the journey of your PhD has to start, that you have to start being aware of the assumptions with which you come to come to an area and come to a project like this. Then I will basically make the argument that when you're doing research in family law, or for that matter in any other area of law, you have to bring a critical approach to your research. And I have given you some examples of the kinds of questions that you could pose, but that is just an example and not an exhaustive list of questions that can be asked in the set. So just to refresh your memory of what kind of questions you are expected to be asking in doing a PhD, I took this slide from Professor Dhanda's presentation and have added my comments in red font just to get us started. So casting your mind back to your first presentation in the series, Professor Dhanda asked you to ask what, when, and where questions, but focus on the how and why questions. So what I'm saying to you is that when you focus on the how and why questions, this requires you to look at questions other researchers raise but don't answer. Doing research in any area demands of you that you become very familiar with the kinds of writings that are available to you. So what the first step in doing research is that it requires you to identify and read the relevant literature in law, but not only in law, and it also requires you to read in other disciplines. So when you are doing an LLB or even doing an LLM, at a pinch, you might get away by confining yourself to only reading about a topic in legal literature. When you have come to the stage of doing a PhD, I would suggest very strongly that it is not enough to confine yourself to legal literature on any area of research, but you need to go to other disciplines. And when you are asking questions that address issues in a new way, the question for us is, new way means what? That nobody has thought of it? Probably not. So what a new way of asking questions invariably will involve is that you will be able to ask such quote unquote new questions if you read widely and you read the literature in other disciplines to do with families, for example. So in other disciplines, when you're reading, you will not be reading only about family law, you would be reading about families. So it is absolutely essential that before you identify your particular topic, that you are completely acquainted with what all has been written about families, not only in law, but in other disciplines also. Professor Dhanda also said to you, avoid following kinds of questions, that is where the answer is settled, or there is no hard data, or it does not connect to any larger issue. what I'm asking you to do is ask yourselves, why should we avoid these kinds of questions? So if the answer is already settled, what are you going to do? So there is nothing more to be done. So you will have more or less, it is a settled issue, doesn't need any further research. And what you could do if you still wanted to research in that area is make very minor contributions. In a PhD, right from day one, they'll tell you that your contribution has to be original contribution. Original contribution doesn't mean that nobody else has thought about it, but what it sort of impels you to do is that you look at an issue from a different perspective. So in that sense, the answer may appear to be settled, but it may turn out to be not settled if you come with a different perspective. You also are asked to avoid questions where there is no hard data. That is, there is no evidence on which you can use to substantiate your hypothesis or your argument. And in that sense, it would become a very difficult task for you in writing a thesis if there isn't sufficient data available for you to be drawing upon in order to substantiate whatever it is that you are saying. Once again, I will say that this also has more than one way of looking at it, that data is not only empirical evidence. Data is also all sorts of writings, and not only legal writings in our context, it can be writings from other disciplines which you put into use to making your legal argument. And in that sense, again, your perspective will determine whether there is relevant data available or not. So do not confine yourselves to only looking at information available in legal sources. Cast your net much, much, much wider than that. And also, Professor Dhanda's point that don't ask questions that do not connect to any larger issue has to do with that this topic interests me, but it is my idiosyncratic interest and I'm going to pursue it. That's a luxury that is not available to us, because basically what is being asked of us in doing a PhD is to make a contribution that is a useful contribution to the topic, to the area of study, to the area of law that you have identified. So it's not enough to say that I'm going to talk about this topic because it interests me. You have to then take the next step and say, it interests me for reason X, Y, or Z. So with just about any topic that you choose, you will be able to say that this is the reason that others other than me should be interested in looking at these topics. All right. So the requirements of original research for a PhD is requires us to survey the field. Survey the field in our case is not only family law, but families, as I said before. So what are the kinds of things? And remember that I'm expecting you to do this even before you have decided that you're going to work in the area, the broad area of family law. So look at what are the kinds of things that you will look at is obviously legal literature on family law. So very broadly speaking, what are your sources for legal literature on family law would be books, textbooks, monographs, court decisions, journal articles, scholarly articles written by legal scholars. But you can't stop there. So one point that I want to make is that you will not be able to you should not confine yourself to only looking at what the legal authors or technical legal sources are telling you. So first point is that you will cast your net wider than just legal literature. The second point is that it is very often said that Indian family laws are unique, and therefore we do not require acquaintance with international literature on family law. That is, our issues, our topics are peculiarly to do with religious personal laws and religious personal laws as they have developed in India. And to that extent, how does it matter what is happening, for example, in Australia? I'm only using Australia as an example because I am situated in Australia and I have spent most of my life talking about family law in Australia. But the point that I'm trying to make is that what is happening in the rest of the world of family law developments, whether it is important to us or not, becomes your very preliminary issue. That is, can you really write a PhD in family law in India without having to refer to what is happening in other parts of the world with regard to their family laws? I would suggest to you very strongly that you do need to acquaint yourselves with what are the kinds of issues that other countries, other nations, other societies are grappling with regard to their family laws. It is not a good idea to say that I am in India, the issues in India are peculiar to India, because amongst other things, we live in a global society, and what is happening in one jurisdiction or one country, one nation, is willy-nilly influenced by what's happening in other parts of the globe. Another question, another way of putting the same objection is to say that Indian family laws are religious personal laws. Therefore, the question arises whether interdisciplinary literature on families is relevant at all. That is, there may be an argument for us acquainting ourselves with literature on interdisciplinary literature on families in many cases, but with regard to religious personal laws in India, it's totally irrelevant, because when sociologists, for example, in Europe talk about the origin of families or the development of divorce, discourse, etc., it's all irrelevant for us. I would suggest to you again that do not adopt that approach, because what is happening in India is connected to what is happening elsewhere, and having a knowledge of how scholars are talking about those developments gives us insights that would not be available to us if we did not make it our business to talk about family laws in India in that broader context. All right, so first, up till now, what have I said is that I think that if you decide to work in this area of family laws in India, you need to first acquaint yourselves with all sorts of writings on the developments in families, whether these developments are in the disciplines of law or in the disciplines of sociology, economics, politics. there is no limit to what can be relevant for us. So read widely. Do not confine yourself to reading only legal literature. That will put you in a very good position to start asking relevant questions. Another initial issue that researchers are asked to settle is that you should settle on the kind of research you want to do. That is, you want to do theoretical research or empirical research, which is a shorthand for saying statistics-based research or evidence-based research. I would very strongly suggest that this is a false dichotomy. There is no such thing as a theoretical or only empirical research. Every position that we adopt is ultimately based on a theoretical basis. The task that we have is to identify our assumptions of where are we coming from in even putting forward a hypothesis or an argument, and more importantly, to be able to identify the assumptions on which other people are writing. So anytime you're reading anything, the first question that you have to be alert to is, what are the assumptions this author is making to make the kind of argument that they are making? Learning to identify the assumptions on which any argument is based is basically identifying the theoretical basis of that position. So what I'm saying is, do not get caught up in this way of thinking that you can do either theoretical or empirical research. The two are absolutely interconnected. And what our task has to be is to be able to identify the assumptions on which any argument is based. This will come in handy when you're reading other people's work, and it will definitely help you articulate your research questions, which will be sound questions. The second question, the second objection, if you like, in this regard is that interdisciplinarity, whether it is an option or a necessity. As a legal scholar, we have been trained right from our days of LLB and to a certain extent in LLMs also, that we legal scholars only need to learn about legal technicalities. That is, of the legal rules and of judicial pronouncements, and not much more than that. So you can write treatise upon treatise talking about Supreme Court's analysis of legislation X. Or you can talk about how legislation is formulated in area Y. Or you can talk about why a certain rule should be formulated in a certain manner, or why it should be interpreted in a certain manner. But all that you're doing is focusing on the technicalities of the rules. That is the idea that legal research is about technicalities of legal rules. I would suggest that if you have decided to do a PhD, it is time to question and to abandon this confidence in the boundaries of legal research as about technicalities of legal rules. And this what I'm saying is requires us to go into a little bit more detail about conception of legal knowledge, and that's what the next slide is. All right, what do I mean by conceptions of knowledge is basically, I want you to become alert to questions like, what is knowledge? Another way of saying that is, that's kind of a what can I say, a polite way of asking, another question of why should one believe what is said? Okay, I want to say something. I have the liberty to say it, but why would it constitute knowledge or valid knowledge and not just my subjective personal opinion, which I'm entitled to hold, but I have no reason to expect that anyone else will go along with that view. So, what constitutes knowledge is basically that knowledge is telling us something that is true, that is objective, that is authoritative, that is accepted by people, that is not questioned to such an extent that we wouldn't believe in it. So this is another way of saying when does a view constitute, when does a view become authoritative knowledge? Now, two broad ways of talking about knowledge is what's called a positivist understanding of knowledge and what's called a post-structural or sometimes postmodern understanding of knowledge. And in positivist understanding of knowledge, knowledge is objective truth. How we reach that objective truth, there are methods to use, and this is primarily the dominant understanding of knowledge in the legal literature. That is, legal literature adopts this perspective that knowledge is objective truth. So when the legal rule is enacted and is interpreted, we come to the conclusion that this is the truth of law. Now, this way of thinking about knowledge has been well and truly questioned by the post-structural or postmodernist understandings. And basically what post-structural view of knowledge is that knowledge is not objective truth that is already existing, waiting to be discovered by us. Instead, this school of thought, if I can call it that, is saying that any knowledge, and I want to underline, any knowledge is a product of contest between various perspectives. So the objective truth, the positivist understanding of knowledge is saying that there is a singular understanding, and that is based on truth. Truth meaning that is for the time, even if you want to say for the time being, that this is the correct view of, let me say, law as a generalization. The post-structuralists, on the other hand, are saying that there is no such thing as objective truth because every view comes from a perspective. So instead of aiming for trying to identify an objective understanding, what we need to understand is how any given perspective gains dominance at any given time. So the big difference between the positivist and post-structural view of knowledge is that post-structuralists are challenging the idea that there is something called objective truth. What they are saying is what passes in the name of truth, what passes in the name of authoritative knowledge at any given time is an outcome of tussle between various perspectives. What does that mean? That means that the perspective can change. And this is where it becomes so relevant for us as legal thinkers that perspectives can change, legal positions can change, legal assumptions can change, our understanding of what constitutes law can change if we start asking questions of what is presented to us as the final answer in legal terms. So this is what critical thinking is, and critical thinking therefore questions the assumptions on which any view is based. So remember in the previous slide, I had said that one of the initial things that we have to learn as researchers is to be able to read anything and identify the assumptions on which any view is based. So critical thinking then questions so first you learn to identify the assumptions, then you learn to question the assumptions on which any view is based. So the beginning of research really happens when we adopt a critical perspective, and critical perspective requires us to be able to identify the assumptions on which any argument is based. And remember, I'm saying any argument is based, and be able to question the assumptions on which that argument is based. That is, why should the author be allowed to make those assumptions? Let me give you a real life example here. That, for example, when we say that family laws, equality should be available to men and women in any family laws. Not many people can argue against that position plausibly. All right. So, but we also live in a situation where the big argument is whether religious personal laws ought to be modified to give gender equality to everyone. Now, all sorts of arguments will come in as to why that cannot happen. What I'm asking you to do is, do not get taken in by the arguments that are presented to you as the last word on the topic. Your job as a researcher is to take the position that let me first see where are these. So if there are three positions, let me see what are the assumptions on which each one of these positions, each one of these authors is basing their argument. And the second question is, let me ask, are they entitled to make that assumption? So not even going into the religious differences argument for the time being, let me just say to you, try to imagine that just family law would require gender equality. Okay, leave aside the religious differences question just for the sake of the argument. There can hardly be any argument against the position that a just family law requires gender equality. All right. What does gender equality mean? Does it mean sameness of treatment for men and women? Same rights for men and women? Or does it require us to take into account the different social and cultural positions that men and women occupy in our societies? Which is another way of saying that substantive equality is not the same as formal equality. All right. Formal equality and substantive equality are these two terms now. Which one would you adopt and why? So do you see the point that I'm trying to make is that identifying the assumptions from which an argument is coming is the first step in you asking then, is the author allowed to make the assumptions that they are making? Let me give you the example of maternity rights, for example. what is the huge argument with regard to maternity rights is that women are being given something that is extra, that is more than what men have. And that doesn't mean equality, that means preferential treatment. That means positive discrimination. How would you decide whether equality requires same rights for men and women workers, or that women can have maternity rights without contravening the value of equality? In fact, upholding the right to equality would require that women be given maternity rights. So the point that I'm trying to make is that these two points of view exist already. You have to now choose between one or the other. Why would you choose one or the other? It requires you to be able to answer adequately the objections arising from the other perspective. And this is what critical thinking equips you to do. And that is why it is important that when we are embarking on research, that we adopt a critical perspective. And remember, critique or critical perspective is not the same thing as criticism. And criticism can happen with the assumptions that are already that both of you share, but critique requires you to actually question the assumptions on which any argument is based. So if you were to bring critique to your approach to research in family law, what would that entail? Has it occurred to you to ask the question? I mean, it may very well have occurred to you, but I have just posed it as a question here, that the first issue for anyone doing research in family law has to be, what is family law, or why do we need it? Now, you might say that's a ridiculous question, but may I ask you, what is so ridiculous about it? We take it so much for granted that of course we need family law. Of course, every society has family laws to govern its family relationships. But have you stopped to actually ask, what exactly does family law do that no other branch of law can do? The reason I'm asking this question, or I'm asking you to ask this question, is that answering this question will enable you to think about the functions of family law. So here is a big point that I'm making, that functions of family law usually are very different than what might be its stated aim or aims. So stated aim of family law could be one thing. Function of family law could be an entirely different thing. So let us try answering the above question of what is family law, or why do we need family law? The conventional answer for this is that family law works as boundary marking between married and unmarried persons. That is, it is a status marker, and the status has implications for one's rights. All right. So in conventional literature on family law, why we need family law is because it allows us to identify people as married or unmarried, and our rights are determined depending on our status of being married or unmarried. So it has implications for one's rights. And also, by extension of the argument, when the marriage dissolves, when the relationship dissolves, then what are our respective rights is also determined by family law. Now, the critical answer to the same question is that really family law is about economics, it's about property, it is about gender politics, and this is what also directs us to the functions of family law. So when critical authors say that family law is about economics, what are they getting at? What they are getting at is that you can enter into a marriage if you fulfill the requirements of who can marry whom, etc. Or you can extend the argument to de facto relationships. But let's not complicate the argument. Let's leave that aside. But you know that it is included in the argument. Family laws about economics means that when the relationship, if the relationship breaks down, and when it breaks down, what does the law do? The law only concerns itself with how will these two people now be able to manage their affairs? How will we divide the property between them? How will we allocate maintenance to whoever requires maintenance? Who will provide for the economic needs of the children, etc. There is not a lot of, in fact, there's hardly any discussion about I put all my emotional energies into this relationship, and now the relationship has ended. I ought to be compensated for it. Have you ever heard that argument? I can challenge you. I can challenge you to identify for me where have you seen the argument being put forward or being accepted in a court that how the property should be divided or how maintenance should be granted is actually linked to how much I love my spouse, how much I sacrifice my life for them. Or even with regard to children, how my whole life has been about bringing up children, and it is not fair now that I have to share them with my spouse who has separated from me. The discourse is absent. It is absent from legal discourse. So what is the legal discourse of divorce is? Two people were living together, they have now separated. Let's work out how to create two households with the same amount of money. That was supporting one argument. Excuse me. All right, so how will you do that? Who will have the children? If they cannot come to an agreement amongst themselves, we will have to decide. And how will we decide? We will decide by reference to best interests of the child. How is the concept of best interests of the child interpreted? Is it interpreted by who put in more of their emotional energies into bringing up children? Of course not. Very often, best interests of the child will be decided by who can provide for the material welfare of the children now that the relationship has ended. So what do feminist philosophers say about this? They say family law is about gender politics. All right, the two stories of what is family law or why do we need it, the conventional answer and the critical answer are on the two opposite spectrums. Now you have to choose between these two views. You cannot have the two views simultaneously. You will have to decide which one of them to accept. How will you do it? I prefer this view over that? Or do you have a more reasoned argument for why one view is better than the other view? Therefore, the need for us is to articulate our view of what constitutes valid knowledge. So at the level of a PhD, it is not good enough for us to say that this is my preference, this is my personal preference, this is what I know to be the truth, this is what I know my friends say, this is how I have been brought up. None of them counts. So at this level of research and writing, you have to be able to articulate your view of what constitutes valid knowledge. And what constitutes your view of knowledge will require us to have an overview of the literature on the construction of knowledge. And if this is too big a topic for me to go into, but remember the broad distinction that I'm making is between positivist view of knowledge as telling us the truth of the matter, and construction of knowledge view telling us that it is an outcome of tussle between various perspectives. So what we need then is to acquaint ourselves with literature on how knowledge is constructed. And once we do that, that kind of understanding will enable us to ask, how is the category of family law defined and deployed? What are the justifications for the classification of family law as private law? How can family law be studied as part of and connected to other social institutions? This will in turn allow us to conceptualize a just family law that is not confined. I want to underline, not confined to the limits of talking about religious personal laws and the limits of a secular state. So if you have already embarked upon reading the literature on family laws, you would find that legal literature on family laws in India is basically about the limits of religious personal laws and the limits of a secular state to be able to change it or enforce it, etc. What I am saying to you, what I'm suggesting to you is that adopting a critical approach which allows you to deploy the view of knowledge as knowledge is constructed and is outcome of certain perspectives that we try to justify, not for always, but for the time being. That kind of a view allows us to ask questions which at the moment are virtually absent from the literature on family laws in India. So what I'm suggesting to you then is that a critical perspective is necessary not only to show bias, but to question the values of objectivity and neutrality on which the entire discipline of law is based. So a critical perspective is basically from the mainstream positivist understanding. Anything else is a biased view. So for example, when feminists have questioned aspects of legal literature, legal analysis, etc., what is the standard comeback from the mainstream of legal scholarship is that feminist views are biased. What I'm saying to you is that once you understand and adopt a critical perspective, you see not only that it's not about bias, but it is questioning the values of objectivity and neutrality that the mainstream legal knowledge claims to have. So what the critical perspective is saying is not that we are not biased. What they are saying is every perspective, every point of view carries a perspective. The only thing that has happened is that the mainstream thinkers have used their perspective to call it an objective and neutral standard. So it's not that they are objective and neutral and everyone else is biased. No, critical perspective is saying, learn to identify that any assumption that you're making comes from a perspective. That in itself is not a problem. It's not a problem because there is no such thing as without a perspective knowledge. All right. So once you acknowledge that everyone has a perspective, what is your next step has to be that you justify the perspective that you want to adopt. How will you justify a perspective that you want to adopt in the context of family law? You would have to argue that it creates a more just society, it creates a gender just society, it creates an inclusive society, or I can keep on going like that. So therefore, adopting a critical perspective is necessary because it challenges the values of objectivity and neutrality. If you apply this perspective to your study or research of family law, can we ask the question differently and say, what is the boundary of an area of law that is called family law? Remember a few slides ago, I had said that the conventional answer is that the family law, the boundaries of family law are the creation and dissolution of families through marriage or de facto relationships. A critical perspective allows you to see that what is called family law is not a pre-existing category or concept, but we are the ones who give content to it. The content is different depending on whether we adopt a positivist view or a post-structural view of knowledge. Now, the really difficult question is, can we continue to be a positivist when the constitutive view of knowledge exposes how the truths of positivism are constructed? Now, it might be too much for you to accept in a presentation of about an hour, but what I'm suggesting here is that work on this idea, examine it, question it, and see for yourself that once it is made obvious that constitutive view of knowledge exposes how the truths of positivism are constructed, it is no longer possible for us to be simple positivists ever again. It's a very big ask, but what I am saying is that if you want to do PhD in any area, you really, in today's day and time, you cannot be what can I say, card-carrying positivist. You have to be able to answer the critiques that have been mounted against that view. If, therefore, we come with a critical perspective to talk about family laws, the first question that arises for us, that stares us in the face, is the concept of religious personal laws. Now, how family law is studied, is written about, is analyzed, is used in Indian family law, in Indian legal literature, is that it is a given that is not questioned. But if you had a critical perspective, these are the kinds of questions you would have to, of necessity, ask. It is no longer a question of choice. I can close my eyes and not ask these questions. The questions have arisen and you have to be able to answer them. I suggest to you, so if you are going to do research in family law, the first issue that you have to deal with is that there is nothing sacrosanct about what we call the religious personal laws. You have to be able to look at the history of how religious personal laws came into being, how they have been deployed, and what is the effect of us keeping on using those ideas, and just to use the concept of religious personal laws to say, hey, that is the majority victimizing the minority, is falling into the political battles that are being fought in our names. It's a very big topic, but I would suggest that there are hundreds of PhDs that remain to be done simply in analyzing the origins and development and continued deployment of the concept of religious personal laws. So I have given you a few questions here. You can have a look at them later on. Once you can question the concept of religious personal laws, a space opens up for us to try to imagine creating a gender-just family. See, what is the current state of affairs for us is that we are caught up in religious personal laws are religious, secular state cannot deal with religious laws, therefore we don't proceed any further than that. It becomes a question of minority versus majority, majority versus minority, etc. In this discourse, there is no space. I'm saying no space for even asking the question of what would a gender-just family law look like. Why? Because the political reality is such that we'll never be able to do it, so why bother? Well, I'm suggesting to you that as scholars of the next generation, it is your responsibility to change the discourse. And you can change the discourse by making it possible to talk about religious personal laws are not the start and the finish of family law discourse. Once you can do that, an opening happens for us to start asking questions like, what would a gender-just family law look like that is not confined by the discourse of religious personal laws? So designing a family law, suppose you want to do a PhD, you want to change the current state of affairs, designing a family law has to be your bread and butter activity. But in designing a family law, will you confine yourself only to a legislative exercise? Or would you conceptualize it as requiring more sweeping changes of the legal system, that is, the legislative design, judicial roles, scholars' input, all these aspects become relevant in talking about what is law reform about? How can effective law reform come about? So there is substantive input, substantive ideas input, and then there is the design input. And since construction of meaning happens at all these sites, the role of students of law or researchers in law is to question the dominant views. Now, if you are serious about exploring the idea of a gender-just family law, what are the kinds of questions you would start asking? Would the main goals of family law be creation and dissolution of a marriage or a de facto relationships as well? Only of marriage or de facto relationships as well? Why? What would be your definition or definitions of marriage be? What would your grounds of divorce be and why? Where would the information come from in answering these questions? Does your education train you to identify and address these issues? Is it necessary to draw upon interdisciplinary literature on family to even start asking these questions? For example, what is the history of divorce? You can identify and use examples of such writings in formulating your topics. I have given you Few examples of what all you can do. You can conceptualize the issues beyond the contemporary debates about a uniform civil code. What would an ideal family law look like? At the very least, you can imagine such a law to be a gender just law. What does gender justice mean? Where would you go to find the answers? Legal writings or more broadly philosophical feminist writings would be required for you to take a position. Would you go for formal equality or substantive equality, and why? How would you frame a legislation with the above goals? What would be the relevant information that you require to formulate your rules? What would be a fair distribution of property at the end of a relationship? Would you go only to the legal sources to find the answer? Or would you have to go to economics? Would you have to go to even sociology literature to answer that? With regard to child-related issues, introduce the notion of partnership in bringing up children. Cause of relationship breakdown, will it be only in monetary terms or in opportunities loss also? How is caregiving work given a monetary value? Should it be given a monetary value? If not, what are the alternatives? Where would the answers come from? So you get the drift that the answers will have to come from interdisciplinary literature. So there are certain legislative tasks that you would have to think about. There are judicial tasks that you would have to think about. And basically what I'm saying is that in deciding to do research in family law, push the boundaries. Do not confine yourself to the current definitions of what constitutes family law, and try to imagine what all your family law will cover and why. For example, why is adoption an aspect of family law? Should surrogacy and its regulation be about family law? If not, why not? Should domestic violence be an aspect of family law? If not, why not? And how can family law support the survivor of violence? Should division of property or ownership of property have a role to play in that? So these are some of the questions that I have tried to give you examples of, and I'll let you think about them. I can give you the slides if you are interested, and over to you. So does anyone want to ask any questions?
Thank you, Professor Parashar. We usually take a break so that students can formulate their questions and put them in the chat box, and we'll cluster them and take them together. That's what we've been doing. So you can also take like a 5-minute breather.
All right. So say I come back in 10 minutes or 5 minutes. What do you want?
Yes.
10 minutes. 10 minutes is fine.
10 minutes will be good.
Okay, it's 4:10 by me, so I'll be back by 4:20.
Sure.
All right.
And all the participants, please use the chat box to put in your questions, and we'll take them together. So welcome back. Thank you, Professor Parashar. It's always a pleasure to hear you, and of course the questions that have come up are also reflecting to the idea of the fact that you are able to bring together so many branches of law that everybody struggles with. Okay, how do you delineate? And when you don't delineate, then it becomes too big, right? So if you're going to say, fine, this is legal theory and constitutional law and family law, then okay, then how do I develop a problem or talk about a topic when I have to do so much? So I think there are many questions, but I don't know if you want to start with that question of width, because people are also asking questions about data, people are asking questions on strategies or methodology. Those I will take up later, but if this is the first question that you want to talk about, how does one at the same time have a narrow topic while also looking at, the various interactions of that topic with other branches?
Yeah. Yes, I understand the enormity of the task that you would face as a researcher. What I was trying to say was that you cannot even formulate a topic unless you have a broader understanding of what are the functions of family law, generally speaking, and that does not happen unless you read non-law literature. So my message, if you like, is that you start by reading as widely as possible. Don't confine yourself to reading only family law literature. Read on families, read on sociology of family, read on history of family. Basically, have no limits. Once you do that, then you are better equipped to come back to family law as such. And the first question that you have to be able to deal with in your mind, this is not to identify your topic, but to you as a person, you as an individual, what is your understanding of what does family law do for us? So the conventional answer, as I said, was that family law is supposed to be, this is the legal answer, is about creating a status and dissolving a status, and no other law can do that. So my question to you then is, what is it about being married that changes your legal rights? Other than the fact that you cannot marry another person while you are married, with some exceptions. So basically, it's about the capacity to marry. And when you dissolve the marriage, then your capacity returns, etc. Think about it very carefully. Why is it so important that we have a whole area of law devoted to? Is it only devoted to capacity to marry, or is it devoted also to regulating what my rights are going to be after my status changes? Which rights are affected? So bracket off capacity to marry. What other rights are affected? Think about it. Are your voting rights affected? Are your right to hold property rights affected? Nothing is affected. So maybe 100 years ago, 200 years ago, English law had restrictions on your right to hold property, etc., depending on whether you were a married woman or not. Those things don't apply anymore. So why do we need a whole area of law just to be able to tell me that you can marry or not marry? But it also claims to do more than that. It claims to regulate your rights. So which rights are being regulated? Ask yourselves. The only rights that are being, if you can call them rights, are when the relationship dissolves, what kind of property or maintenance will you be entitled to? Can property law do that? So what my major question to everyone who is thinking of doing research in family law is that property law is basically, family law is dealing with your property rights. That is, when the marriage breaks down, the fact that it was a relationship of economic dependence comes into full view. The fact that it was an economic dependence based upon usually the woman taking up the primary role of being the carer and being the non-financial partner for that reason becomes absolutely evident. Now that the relationship has ended, somebody has to provide for this woman. do you really think that that's a model of creating relationships that is a justified model in today's society? Especially for my law students who are like the brightest of the lot, men and women are equally committed to their professions. And here we are justifying a family law that is talking about when the relationship breaks down, how will we provide for this woman? And what is the discourse that we create? We create a discourse of dependence and maintenance. And maintenance that is given as a gift rather than as a right. So these are the kinds of fundamental questions you need to ask, in that there is a whole lot of literature that is talking about that the existence of family law actually camouflages the economic dependence of the mothers on the fathers in an ongoing relationship, which becomes evident when the relationship breaks down. If you can start at that level of generalization, then you can start narrowing down of what would, in your understanding, be a fair family law. Now, if you want to, I was just reading some of the questions that have been asked. If you then go to how would you have access to the kinds of quotes that Sylvia Batuk is talking about, I would suggest, hang on, don't go there. That's a micro question. That micro question has to be informed by your macro view of what is family law there for. Once you have a very clear understanding of where you stand on the question of what constitutes gender justice, then those micro questions will become irrelevant. So it's not an unmanageable task, but it does require you to have a crystal clear understanding of what do you think family law does and should be doing. Once you have a clear position on that, then any micro question that you ask will be answered by reference to that. So to go to the question of how relevant are the surveys by different institutions help us understand the existing issues in family. No, you do not rely on other surveys to understand. You have to constitute your own views of what is divorce there for, what is marriage there for. If you have an institution of marriage that is legally regulated, then what is it that that legal institution is creating? If it is creating if it is camouflaging financial dependence, do you really want to go there? Then the existing laws of divorce, what do they do? Do you want to look at, for example, if you want to look at the statistics about what kind of people divorce, at what time in their relationships, like in 5 years, 10 years, 20 years, do most divorces happen? Who initiates those divorces? What are the grounds of divorce? What are the consequences of divorce? Has to be informed by your understanding of what would be a just society. So you created a marriage and then you made it possible for divorce to happen. But after divorce, if you find that majority of women end up living in poverty, is that the kind of family law you want to justify? Do you get the point that I'm trying to make? It's no point in going to the surveys that are available, because they can only ever support or challenge the assumptions on which you are proceeding. You have to have a bigger picture of what is it about family law that would help create a just society, a gender just society. So in Australia and in most other developed economies, the trend is of creating a divorce law where at the end of a marriage, first of all, the marriage can end by either party wanting an exit. And the trend is for the law to grant a share of property to each one of them. So even though while in a marriage, you continue to be the owner of your own property, at the end of the marriage, if you can't agree, then the court will come in and divide your property amongst two people, irrespective of who had the legal title. This is supposed to be a socially progressive trend in marriage and divorce law. But the empirical evidence is that despite women getting a share of property, which is much more than just getting maintenance. So remember, it was a very big step forward that women are being granted a share of the property available. Most women with children end up in poverty. So they are, in the literature, they're called the new poor of societies. So where did we go wrong? So we went wrong in assuming that just giving a share of property to the woman at the end of a marriage is enough for her to be able to survive on her own. While the reality is that we are living in a society where economic well-being depends on you being able to earn a living, to earn a wage, to earn an income, have a source of income. Do we want to create a marriage law that actually addresses the issue at that level? That economic dependence is not allowed? Can you think in those terms? Why not? Because we only think in terms of legal literature. We don't go beyond legal literature. So go to how family relationships are being discussed in all other sorts of disciplines. Treat it as a 6 months of studying project. Become acquainted with who are the big names in sociology of family, who are the big names in economics of family relationships. Read as widely as you can, and you will realize that it doesn't look like such a bad area after all, and the micro questions will be put in context for you to be able to answer. So what I'm saying is give yourself the luxury of reading widely, becoming informed, and you will see that the kind of questions you are asking will be quite different than what we are generally asking in family law contexts. I don't know whether that answers the question, but that's
No. I think you have answered it and answered all the questions that are listed there quite comprehensively, because there have been questions on, concept of family law is largely related with old literature and schools of thought. But that's exactly what you're saying, that you need to read much wider and you need to read more than just family law to be able to answer those questions. And the fact that you need a theory of justice before you start looking at research, I think that is true for all good legal research, that you need to have a theory of justice that you want to proceed on. So it also answers the first question, which says that, then doesn't it become something like socio-political movements? So I think you want to answer this question about when you're saying that read wider and, have a theory of justice. What's the difference between an activist and a researcher? This is a question that has come up in the previous workshops as well. Maybe you want to give your own take on, what is the difference and how do you see this difference?
I see no difference. A researcher has to be an activist. See, the term activist is bouncing off this idea that there is someone who's a neutral scholar. There is no such thing as a neutral scholar. That's the point of construction of knowledge idea, that all of us have a perspective that we come from. Some of us get to define our perspectives as objective point of view, and everything else becomes an activist. No, everyone is an activist for the line that they are pushing forward. And once it becomes the dominant understanding that every position comes from a perspective, then the question is not whether you should have a perspective or not. The question is which perspective is justifiable or is more justifiable. So if you're talking in terms of family law, then if you, and I don't think anyone argues against that position, that we would aspire for a gender just family law, then what does gender justice require? Gender justice does not require simple formal legal equality. It requires us to acknowledge the existence of social conditions where men and women occupy very different positions. If you acknowledge that, then you will not have a divorce law which says that you can have maintenance at the end of a marriage for 5 years or X number of years. You will have to acknowledge that we need to provide for these two people. Who is going to provide? Is it going to be the individuals? Is it going to be the society? Is it going to be that we will not allow economic dependence to take place in the first place? So the issues become much larger issues than just specifics of what part of property or what maintenance should be awarded.
If I could just add on, because the way I'm sort of processing the questions, connecting it to what has happened before, is that at one level they have been advised to scope. And so they're getting confused now between that if you're asking us to scope and at the same time you're asking us to read widely, is there a contradiction in terms in what kind of advice is being given? So I think Archana has kind of clarified it, but I just want to connect it with, it's like before you scope, before you sort of decide, okay, this is the thing where I want to latch on, you need to be knowing your terrain much better. So the point that is being made, I think, repeatedly is this, that familiarizing yourself with the terrain, don't only make a legal entry there. Don't just look at legal materials. The more different, varied kind of materials you will look at, even if you are then going to find this chotu thing which you're going to work on, you see where this chotu thing is connected with the larger thing. But if you start from this small thing, then necessarily what you turn out is like, just a recycling of already available material. A maximum, or just a compilation of everything which has come in there, and it takes a hell of a lot of effort to do even that. So you can't comprehend why people then poo-poo it away and say, what did you do? So I think that's the connection I would suggest you need to make, that the wider reading is something which is being spoken of as a way of, like familiarizing yourself with the terrain in which you want to work, and then to say, okay, this particular peak is where I am going to, what Vasanti has this term, where I'm going to land. This is where my landing is going to happen. But before you do that landing, it's important that you look around and say, where should I land?
Yes, and I think that's what I'm trying to get at, is that give yourself 6 months to read widely. So once you have decided that you're going to do a PhD, you cannot just front up with a topic. You have to allow yourself to be informed of what are the wider issues that are being discussed in other disciplines on this topic, and then come back to the law aspect of it, and then come back to the, instead of family law, to one aspect of family law, but it will always be related to the wider context. So whether divorce should happen on grounds of, for example, mutual consent, or even like what is called a divorce on demand, there are many answers to that, but the answers have to be happening in a particular socio-political context. But if you don't understand the socio-political context, you'll never be able to link them up. So is there an answer to the question of what should be the ground of divorce? Of course there is an answer, and it will be, your answer might be different than my answer. But the important thing is that I'll be able to justify, or you'll be able to justify your answer by reference to the wider literature in the end. For example, if the literature says that majority of women who are divorced end up in poverty, what is my solution to that? My solution to that can be don't allow divorce, or my solution to that can be don't allow economic dependence in an ongoing relationship. So those are the kinds of issues that allow you to make a deeper argument, but that will only happen if you read widely to start off with.
I want to take you back to the question about research and activism, because one other way in which this was answered is that the idea of an activist is a person who only sees one side. Who doesn't see the other side, who doesn't take a very, a well-rounded perspective of any issue. And that is the kind of an image of an activist that we're trying to dispel. Not that one shouldn't be passionate about your position and that you should be committed to your position, but that you shouldn't kind of not engage with the other. Would you want to reiterate that is a useful way of proceeding with this?
Yeah, because research at the level of PhD requires you to have a reasoned argument. And you cannot have a reasoned argument if you haven't answered your opponents. So of necessity, you will have to address what are the other perspectives and why your perspective is the one that is worthy of persuading your examiners, for example. So it's like rather than taking the easy option of saying that this is the objective view, which is not an option available to us anymore anyway. But whatever position you take, it is your responsibility to answer all the counter views to that. And that's what survey of literature means. That I know that there are 10 other people who are talking about this topic in a different way than me. My reasons for adopting this position are these. This is not activism. This is taking a position and substantiating a position. You cannot do a PhD without taking a position and substantiating it, but that is not called activism.
Thank you for answering that. So the other question that is of great significance in family law, and that is what Harpreet is asking, that we call it, though we say family law, it's Hindu law and Muslim law and Parsi law. So this whole business of how to engage with religion, I think in all other branches, we somehow get by without really engaging with it. But in family law, we really need to engage with that question really in a very hard way. So how do you suggest that we go about doing this?
I think, that's what I was trying to say by looking at the concept of religious personal laws. To accept this idea that religious personal laws are about religion is to accept the dominant discourse. Go behind it. Do some analysis, do some historical research, do some philosophical analysis of the concept of personal laws. Where did the concept come from? For example, historically, the distinction was between personal law and territorial law. And the argument was that when you traveled, when you were a resident, domiciled person in one jurisdiction and you traveled to another jurisdiction, which law applied to you? The distinction that Western law came up with was that when you went to another territory, you carried your personal law with you. That is, even though I happen to be in country X, my personal law of country Y kept applying to me while I was in country X, because I was not going to live there permanently. I was going to come back. So that concept of personal law traveling with me was the origin of the idea. When the English came to India, this is what they used to not have to deal with the difficulties of communities based on their religious differences. It was a political device. And how it has been used subsequently is that not that religious personal laws have remained frozen in time, but how their discourse has been created that this is the argument we use um, to ward off what we call unwanted interference from outside. But who are the we who ward off unwanted interference in itself becomes an important legal question. So you could have a very good PhD topic in trying to work out that in accepting or not accepting interpretations of what a religious personal law is, whose voices have been heard and whose voices have been silenced. The enactment of what was that after Shah Bano, the Muslim Women's Protection of Rights and Divorce Act, go into the legislative history of it and see the shocking detail of who's being listened to and who's being ignored. Similarly, when the last law has been enacted, I don't remember the name of it, where they are trying to, or they are criminalizing Muslim men who might marry more than once. Was that the only model available? Whose voices are being heard and who's being silenced? This is not religion. This is politics in the name of religion. That's what you as a scholar can do, that you can analyze the history of how a certain legislation has come about, who's being empowered, who's being disempowered, and here's your PhD. Would make absolutely original contribution and give short shrift to the argument that religious personal laws are about religion. Mm-hmm. So don't get taken in by the dominant discourse, and that is your universe of ideas. Go beyond them. Go find out why is something being talked about like it is being talked about. With regard to the Adoption and Juvenile Justice Act, look into the history of how adoption. What is the history of adoption, the state trying to regulate adoption as like through legislation? Fascinating history. When the objections happened amongst others from the Christian priests of various South Indian churches in the name of our religion. That is, Christian law is a religious law that does not allow adoption to take place for X, Y, and Z reasons. But when you look at what is the Christian law that is in existence in India, anything that goes under the name of Christian law is actually the relevant English state secular law that was in existence in England at that time. For us to be caught by this argument that this is Christian religious law is absolute, what can I say, nonsense. So go do your historical research, do your see, when you talk about Juvenile Justice Act now regulating adoption, absolutely brilliant topic for research, in that what did the state do? It tried to regulate adoption for X number of years, did not succeed, in the name of religious laws being the problem. They quietly enacted a Juvenile Justice Act. What are you going to do about it? We are not calling it about adoption, we're just saying it is Juvenile Justice Act. And what have we done under it? We have made it possible for adoption to happen without any connection to religious arguments. But the wider question here is, what is this concept of adoption? Adoption is basically something that is a legal fiction. So what does it do? It creates this fiction that you were born in a different family than what was your biological family. Why is that necessary? because the law cannot deal with a child having two sets of parents. Why can't the law deal with that? Because we have never done it. All right, you've never done it, start doing it now. Why create this whole story of that you were born in a different family than what you were born in originally? If it is about the best interests of the child, every psychologist will tell you that it matters to the child who their biological parents are. Should we even have a concept like adoption? Here's a PhD topic. Go and do it. It will make for an original contribution. Mm-hmm. So these are the kinds of issues that become possible if you cast your net a little bit wider than just talking about legal issues.
I think that also ties up with your point of reading from different jurisdictions, because sometimes the diversity of legal systems is something that we don't really engage with, and especially in family law, I think that becomes it really throws up things and opens up things which are otherwise not so clear.
True, but we are also living in a time of like such access to information and literature that, for example, when I was doing my PhD was unheard of. But now, if you wanted to, you could very quickly acquaint yourselves with what is happening in, for example, a similar jurisdiction to yours and a dissimilar jurisdiction to yours. Here's your comparison. For example, if we talk about religious personal laws, what about countries where other ways of dealing with religious laws are in existence? A comparative study of, for example, Muslim-dominated or Muslim societies would be a fascinating study. You'll come home deciding that India lags behind just about every Muslim country with regard to which laws are allowed to be enforced by the state or not. That would allow you to sort of pursue the argument that this is not about religion, this is about politics, this is about gender politics. So those are the kinds of things that can happen. If you were, for example, to look up how civil law countries are dealing with the issue of de facto relationships and how common law countries are dealing with de facto relationships, you'll find that civil law countries are quite happy, France being the dominant example, of treating marriage as a contract. They call it a contract. They don't even pretend like we do that it is a sacrament or something special about it. No, it's a contract. If it is a contract, then you can have specific clauses saying that economic independence will be taken care of, or economic dependence will not be allowed to happen, or whatever. But we don't go outside our paradigm of marriage is about love and affection, but it is not. I mean, it is, but the law doesn't want to know that aspect of it.
So can you elaborate a little more on this whole business of, how rationality has dominated the understanding of the law? So the whole business of emotion. So can you take it a little forward? How do you think that aspect becomes part of research or doesn't become part of research? What do you think? How much? Because there was a question that came up in the constitutional law lecture about understanding the fact that the constitution has no space for any kind of an emotion. So how do you see it? Have you thought about it? Would you like to share something on that?
Basically, you have to think about that this law confines itself to dealing with certain aspects of your relationships, whether as a citizen or as a family member or as a contract agent or whatever. In all of these, what it wants to deal with is what is a tangible thing. So what is a tangible thing? That in a contract relationship, for example, that the two contracting agents are equal legal subjects. Equal legal subjects is not equivalent to equal equally empowered, informed individuals in society. But law's way of dealing with that is that if you are a multimillionaire and if you are a employee of that multimillionaire, we'll treat you as two equal legal contracting agents. So why does the law do that? The law does that for the advantage of maintaining the current disparities or the current distribution of wealth and power, etc. So then you can go into the whole business of what is the law there for. The law is there for creating a just society, or it is there for maintaining the class divided and socio-economic divided societies that we have. So when the law says we will only deal with you as two equal contracting agents, it is closing its eyes purposefully to the power disparities. So it's not an innocent choice, it is a considered choice. So I wouldn't call it that law is rational and that's why it doesn't deal with emotional aspects of our lives. No. It is a mechanism of maintaining the stratified societies that we have, stratified in many ways. And we use the concept of rationality, but we use it only partially. So if you think of two legal subjects as equal contracting agents who are acting as rational agents, give me an example other than marriage where one person is willingly entering into a relationship to become a dependent on the other in our modern societies. Can you give me one example? The employer and employee also is not that much of disparity. We don't allow slavery, but we allow marriages to happen, which is a glorifying of economic dependence. Why? Because we need the next generation. Somebody has to provide that care and nurturing for the next generation to come up. Once we start articulating that, then how are we stopped? We are stopped by saying, hey, you're too instrumental, you are too money-minded, you are too cutthroat in your understanding. That's not what families are for. Families are for love and affection. Okay. Then what happens to the love and affection when the marriage breaks down? Then it becomes about, you should have made the right choices. Don't expect maintenance for the rest of your life. Go get a job. Become financially independent. Can you imagine us making the same arguments at the beginning of the relationship? Why not? It's not about emotions and rationality. It is about maintaining social stratification at various levels. So when family law says that we don't want to know how much love and affection you poured into it, why? Because it says there's no putting a monetary value on that. But I need money to survive. I gave up. So think about all of you who are studying and wanting to do PhDs. Why are you doing it, men and women? You're doing it to become professionals, to be able to stand on your own, to be able to be self-sufficient and progress in life. But the big difference, I'm sorry to say, is going to be that as a woman, you will also have the primary responsibility for children. Primary responsibility. If, unfortunately, your relationship ends, the man and the woman is not going to walk out of that relationship on an equal footing. Any amount of legal tinkering is not going to manage that economic disparity. Do you see that with the help of family law, we are actually justifying the making of a society where economic dependence is not talked about and is hidden under the facade of a legal institution? Think about it. Why is it such a radical idea that economic dependence should not be allowed? Why? I do not for a moment want to suggest that you guys should not enter into loving relationships. Just do it with your eyes open. That's all. Don't be surprised.
Thank you. Thank you so much for answering that so comprehensively. I have a more practical question coming from, I think this is Dikshita, who says, okay, people ask for a detailed synopsis before the interview. How do we convince the panel? Because all of us know that the reading is ongoing. We wouldn't have read everything that is there, and especially at the stage of the synopsis, it's certainly not the end of our reading. So then how do we persuade people when our reading is at that point not done?
That is okay. So I think you mean Dikshita Das question?
No, this is Harpreet's question. This is a question before Dikshita, where she's asking some universities ask for detailed synopsis before interview. How do we ensure we are prepared to convince the panel, considering the research at that time might be insufficient?
That's okay. That's always going to be the case. So how you put forward your detailed synopsis is that you have thought of the question, and that's what I mean by that. For you to write the detailed synopsis, allow yourself 6 months of reading very, very widely and identifying your question in the wider context. And it's the formulating of the question that is important, not the answer. The answers will come from subsequent research, but the question cannot come from subsequent research. That's what the universities are saying. You have only 3 or 4 years and they fly. So it is in your interest that when you start your PhD, you have actually put in at least 6 months of intensive reading, so that you are well aware of what are the issues that are being discussed, and of all those issues you have identified one question as relevant, and why is it relevant? You should be able to justify that. The question should be justified. The answers will happen later, and I don't think any research panel would expect you to have the answers at that stage. So the distinction is between being able to justify the question and saying that the research for the answers will happen by looking at these sources of information. So that is what is important, that choose a question that actually where will you go to find the answers from. If you don't have an idea where your answers are coming from, you're setting yourselves up for the fail. So, and that's what the function of wider reading is, that allows you to identify where your answers might come from.
Yeah, I suppose what we often find, like from proposals, and I think Harpreet, that would possibly help you too. What we often find is that people kind of go and latch on to some kind of a topic and believe that once it is registered, subsequently they will go and find out what is there to research in it. And that's where it's not. And on the other hand, if you have done all the reason for why this is research worthy, that kind of work you have done, what the research will entail, what will come out, nobody's expecting from you. But if you've not even done the research to reach the topic, and you expect that, like you have some 5 random conversations, look at 3.5 articles, and you believe that, okay, you have a topic and you can register. And then you sort of blame a system and say they're asking for a detailed synopsis. My thing is, are you able to present that, yes, I have a solid research question. This is worthy of research. What will come out of it, I can't say today, but this question needs to be researched. The point which Archana has made throughout this morning has been, she's saying that read enough that you can justify why this is relevant. You will be asked questions around that. Very often what tends to happen, and I'm not sort of saying research boards are also of all kinds. I'm not in any way exonerating and saying, but I'm just saying this, at least for us at Nalsar, it becomes extremely important. If you have a good research question, we'll register you. We're not looking for anything else. But if that work has also not been done, then to be coming up with some, actually we ask for a 1,000-word proposal. We don't say anything more. We say only 1,000 words. Within 1,000 words, tell us what is that question you have found for which we at Nalsar should register you. But if you are giving a 12 or 15-page thing, but it's actually just going round and round around a topic and not having a clue of why this is research worthy, then I think every research board is entitled to reject.
See, it's a bit like saying that in family law, if you want to research on grounds of divorce, why do I want to talk about grounds of divorces? Because what our laws at the moment are inadequate. So what are the steps that I'll have to take to make it a acceptable topic is that I will talk about that religious argument is not going to stop me finding an answer to this, because I will show that the concept of religious personal law is a construct or whatever. Then I will look at what are the reasons why divorce came into being, a little bit of history of divorce in the Western countries. Where are they at the moment? Our society is not the Western society. What would those kinds of grounds of divorce do for our society? What will divorce achieve in our society? What is my fundamental aim in even starting to look for it? Is I want to create a possibility that a family that is no longer functioning ought to be able to be dissolved, but with equitable consequences for both parties. If you said that much, I don't think any research panel will have any difficulty in accepting that as a possible research topic. It's just an example. You could do that for any topic. With adoption, for example, you could say why the concept of adoption should be continued to be used. Is it in the best interest of the child? How do we conceptualize best interest? What are the arguments for and against? And why I want to take the position that adoption ought to be allowed or that adoption should not be allowed. I'll take one position, but I will answer the other position.
There is one more question if you want to take it from Dikshita Das. Working on religious conversion laws vis-a-vis special marriage, and she's wondering how to connect the two and what would be a good way of looking at this area.
Yeah, it will be absolutely quality research if you can cast your argument in a more expansive sense, in that special marriage act is there because various religious laws do not allow interreligious marriage. Okay, if you look at the history of religious personal laws, as I've been saying, you can see how it is not about religious sanctity of rules. It is more about how those rules are used for various political purposes. What you could say, I'm not saying that you have to say, but what you could say is, let me imagine, is it possible for us to create a discourse of family law independent of religious personal laws? So religion is about my faith. It is about my personal conviction. Should I be relying on a secular state to enforce my religious rules? So there are various ways of looking at religious freedom. One issue is that, is it any business of the state to make me a good religious person, whether a Hindu or a Muslim or a Christian or whatever? Okay. So if the answer is no, because after all it claims to be a secular state, what other options are there for a legal model? Can we create a family law from scratch that is independent of religious laws? Can you imagine a scenario where we will not be talking about uniform civil codes, we will be talking about a just family law, full stop? As a Muslim, I'm not allowed to do certain things. The family law that we are creating doesn't force me to do that. As a Hindu, my law allows me to do certain things. If my state family law does not allow that, what will I do? Will I stop being a good Hindu because I'm not doing that? So there are ways of talking about religious conviction, religious fidelity to your ideas, without it having to depend on the state to enforce those religious injunctions. And very often the rules are enabling rules. So what you're saying is that the state law is that you can do X, Y, and Z. If there is something extra that needs to be observed for me to be a good Muslim or a good Christian or a good Hindu, I go and do that irrespective of whether the state law enables me to do that or not. It prohibits me from doing that. Does that make me not a good religious person? So if the law prohibits me, the state law prohibits me from, this is controversial, but I'll use it anyway. If the state law says monogamy is the only way of marrying, my religion permits me to have polygamous relationships. Do I have to call it a state-enforced marriage for me to be doing what my religion allows me to do? Do you see what I'm trying to get at? That religion, if I am so convinced that to be a good Muslim, I have to be polygamous, then I can go ahead and do that anyway. It will not be called a marriage under the state law. Under religious laws, you can call it whatever the religious law says, but the religious law is no longer being enforced by the state law. It is, let me give you another example. Catholicism, Catholic law does not allow divorce, full stop. Every Western state that has Catholics living under it allows divorce. As a Catholic living in, say, England, if I choose to divorce, do I stop being a Catholic? Maybe under Catholic rules I do, but I'm making a choice under the state law. If the state says, no, you are a Catholic and that's why you will not be allowed to divorce, but everyone else can divorce, then is that a secular law? Get the point? That the state law does not have to enforce religious laws in a secular setting. If that is the situation, then we do not have to have a special marriage act and religious personal acts. Your religious laws are there for you to live by them if you choose to live by them, but you do not have to expect the state to enforce those religious laws for you in the name of religious freedom or in the name of equality, religious equality, etc. There are ways of thinking around the same situation. So for Dikshita, I think the wider context for you has to be that what are family laws there for? If family laws are there for reasons of creating certainty about a status, etc., then let there be a state law that does that for everyone, irrespective of their religious differences. Let people decide for themselves what religious rules they want to live by. The conflict doesn't happen. The conflict happens when the state says something and the religious law says something else, and you come and say, the state law is preventing me from living by my religious laws. Doesn't have to be that way. You go and do what you want to do as your religious conviction, but do not bring the state law in to enforce your religious convictions. And it's not an outlandish idea. A lot of even Islamic countries have modified the aspects of their religious rules in the name of social justice, equality, and so forth.
So I think we have some time for an open house. So those of you who have not been able to access the chat board, you can unmute yourself and if you have a question for Professor Parashar.
I don't think there's a lot of activity.
So are we done?
It seems
Or is somebody still reflecting?
I don't see any hands up. You can put up your hands if you want to ask the question.
All right, then I think we are done for the day. I would just somewhere want you all to connect today's exposition with what has gone before, and you'd find it as a reiteration once more that all right, what becomes the most critical thing for being able to work out an original contribution in a manner of speaking, which is the running theme of these workshops, is for you to be to do that search to find the question which requires a research. I mean, it's in a manner of speaking, it's that kind of connection that is we made. One thing which came through very strongly with Ashna's presentation, the other thing which I think she brought out very majorly, and I think that possibly a lot of us here, because a lot of Indian education doesn't really encourage scholars and students to take stands, to be recognizing the fact that no, if you are going to do research in an area, and if you are going to make a contribution, you need a position. You have to think it through. It's not, but to say, oh my God, if I take a position, I am no longer that neutral, objective researcher. It's like, if you don't take a position, then you're no one, neither neutral nor objective nor researcher. So it's like in a way worse situation. But more importantly, what lands up happening is that your so-called neutrality is more aligning with however things are being done till now. And it feels safe. It feels like, okay, this is something for which so many people are giving me endorsement. So if I continue to, or if I do it, there is no big, it's not so threatening, it's not so scary. But it's like a certain level of balancing on the precipice and ensuring that you don't fall over is a part of what you're meant to do when you're doing research. I think all your questions, which came in a very micro kind of packaging. Okay, Noor, why don't you say it, Ma? It's a little late for chatting now. Noor, you have a question?
Hi, ma'am. No, I just wanted to ask you, if ma'am can just reflect on the question, if family law can be imagined within the law and morality framework, like conceiving it as something, as a tool of the state to enforce a certain set of morality on people. So, state is doing the business of society through its laws.
Yeah, definitely is, and all laws are like that. So the question is, what's the problem with that? So every area of law has a certain what can I say? I'm not using the word morality, but has a certain set of values that it is supporting, or it is endorsing. What's the problem with that? That has to be your question. And with regard to family law, obviously the question has to be, does it lead to a gender just society? So even you're asking that question then would help you identify that really you're looking for achieving justice through family law. If it is not happening at the moment, then how will it happen? What is my concept of gender justice? So for a state to impose its certain set of morality on people, what's the problem with that? If I was in your position, I would say the problem with that is that it doesn't lead to a gender just outcome. Women come out less empowered than men most of the time, and that's a problem, and that's why it needs to change. Something to that effect.
Okay, thank you, ma'am. Thank you.
So what I can offer is that if you are struggling with a topic and you would like a little bit of a to and fro with me, you can send your questions through, I don't know how, IT support, or Amita, I'm asking you.
Yeah, you could they could send it to us and we could forward it. Or if it's okay with you, we can share your email, whichever way it works for you.
Yeah, let them send them to you, and then I can manage that better.
Fair enough. That's a. I mean, I was just even the question that you've asked, Noor, it ultimately just goes right back to that you don't ask foundational questions. It is very foundational, no? That if it is personal and if it is a family law matter, then why is it that on certain things the state intervenes and other things it doesn't? Where is it that you're saying you'll come in and where is it that you won't? And if we are going to see that in problematic terms, then evidently you start getting a question there. If you see it like, oh, this is what is happening, and that's all that we are detailing, then necessarily we run into this problem of just, collating a whole range of information, but being none the wiser for the whole analysis, because we have not reached the point where the harder question has been asked. So I think I can thank you, Archana, for this really, really fascinating morning, because suddenly it becomes like, family law, which is like supposedly seen as one of the soft areas of law where no hard questions really arise. And, to be seeing that how much of, your very core, in fact, your core being questions are so linked up with how you are, envisioned in family law. I always sort of keep asking as to, why is it that trans people or people with different sexual orientation, why are those questions seen as discrimination questions and not family law questions? After all, everybody was in some point in some kind of, whether functional or dysfunctional family, they were members there. Remember when we did the book also, it was like we decided to look at this question only for this reason, that because we've got Prabha Kotiswaran coming speaking tomorrow, that connection she saw between the wife and the whore. To say that if you believe that the sexual economy is going to have no impact on what happens within the home and family, you're really not comprehending what's happening. And because the way in which those boundaries are lined out for us, and if you then enter the field within those boundaries, you don't even know what is it that is problematic. And consequently, you keep asking these, like whether restitution of conjugal rights should be constitutional or not constitutional, and you don't go beyond that. So that's the. So thank you very, very much, Archana. And thank you, Vasanti, as always, for doing an amazing moderation job. And thank you, participants. I mean, what is really good for us, we're not anyway not looking for numbers. We're looking for qualitative interaction. And I think that we have been finding in each of our workshops is fulfilling even for a resource persons, if you've got people on the other side who are asking you focused questions. So thank you very much. Tomorrow, I think, as the IT support people will tell you, our session starts in the afternoon. It's, I think, from 2:30 to 2:30 to 4:30, because Professor Kotaswaran is based in London. So we've got one person from Australia today, and we've got, somebody ahead of us and somebody behind us. So we've got
You are covered.
So thank you very much.
Yeah, thank you
very
very much.
much. It was a real pleasure. Thank you so much.
Bye. Bye.